The first case is Cayuga Indian Nation of New York, number 74. I'm sorry.
May I please reserve 4 minutes for rebuttal?
4 minutes for rebuttal, counsel. You have it. Go ahead.
Thank you, Chief Judge. Good morning. Philip Spillane from Harris Beach for the sheriffs and district attorneys of the counties of Cayuga and Seneca. The counties asked this court to reject the interpretation of the New York tax law 470-16 sub A as proposed by the Cayuga Nation. The Cayugas contend that their open market purchase of any land within the 64,000-acre parcel that they have not owned, occupied, or governed for nearly 200 years.
Well, why does it matter whether this is reservation land?
Judge Smith, the issue here is the determinative issue. One determinative issue is whether this land qualifies as a qualified reservation under 470-16.
470-16 is, as I remember, is a definition.
Correct.
And the term it defines is in 471E?
Yes.
That it defines a term appearing in 471E.
Correct.
471E is a statute that has been held not yet to be effective.
Yes, but the issue, Judge, is whether this property, these two convenience stores, constitute a qualified reservation. And if they do constitute a qualified reservation, then the Cayugas would be able to sell tax-free to their own.
Why is it not a qualified reservation?
Justice Gravio, it is not a qualified reservation because the definition that the Cayuga Nation relies on is 470-16 sub A, that essentially says that a qualified reservation is a reservation within the state of New York, within the state boundaries. The issue in the lawsuit is whether the word reservation, as used in 470-16A, is sovereign land or non-sovereign land.
Well, are they asserting sovereign immunity?
They concede it is not sovereign land.
So can't there be a distinction between land over which you assert sovereign immunity and that which could be viewed as a qualified reservation?
Judge Gravio, I think if you accept that, or if we consider that, I think it leads to one of two unacceptable resolutions. Let's assume that the land or that the reservation, as defined in 470-16A, means land that is not sovereign. And the Cayugas concede the land is not sovereign. There's no doubt about that. It's an acknowledged fact. But if that's the case, if reservation in 470-16A means non-sovereign land, then that word reservation, as used, as advanced by the Cayuga Nation, would be absolutely inconsistent with the exact same word, that is reservation, as used in the Real Property Tax Law 454 and Indian Law 6.
What's the practical effect of that if we accept the Cayuga Nation's definition?
Well, I think, Judge Piggott, that the practical resolution is this. Number one, we're going way off the map with respect to statutory construction. I respectfully submit that it would be impossible for the legislature to.
What about the checkerboard effect?
Well, Judge Reed, that's exactly the problem. If this land is non-sovereign land is a reservation for the tax law, then that would mean that the Cayuga Nation could buy any parcel within the 64,000 acres. And then, inasmuch as, if we get beyond the pari materia argument, that is, that it would be impossible to have the word reservation mean one thing in the tax law and another thing in the real property tax law and the Indian law. That is, clearly, the exemptions under the real property tax law and the Indian law flow from sovereignty. The word reservation in the latter two statutes clearly means sovereignty. But if we say that for the purposes of the tax law and the definition of qualified reservation, that reservation means non-sovereign, then we've got the conflict, the pari materia issue. But it would allow, if you accept that definition, it would allow the Cayugas to buy any parcel within that 64,000 acre, and turn that into tax-exempt property.
Well, now but they are paying real property taxes?
They are. By their conduct, the Cayugas concede that this property is a reservation. It's not a reservation.
I think I understand your argument on what qualified reservation means, but suppose just hypothetically we were to disagree with it. Would that mean you lost the case?
No, absolutely not, Judge Smith. If you take their argument that reservation means non-sovereign, then I think we have to ignore the plain...
You're not, that's not my question. Assume that we are, I understand you think it would be ridiculous to say this is a qualified reservation. Suppose we agree with this. Suppose we are that ridiculous. Suppose we say this is a qualified reservation. Does that mean you lose this case?
No, Judge, because then you fall to 470. If it's qualified reservation, then you go to 471. But if I could...
Well, you've got to force it, yeah. I guess that's what I'm getting at. All this argument is about defining a term in 471E, right?
Well, it's defined in 470.16a.
Yes, but the term that 470.16 defines appears in 471E.
Correct.
And 471E doesn't exist. 471E isn't effective yet.
Because the regulations have not, because the coupons have not.
Yeah, so why do we care what it means if it's never come into effect?
Well, what the Cayugas are saying is that the land is a qualified reservation.
I understand that they're saying that. Why does that advance their cause?
Because what they're suggesting is that they come within the definition. Obviously, we don't agree with them.
Isn't it that it has to be exclusive in order for them to prevail?
Exclusive.
That that 471E has to be exclusive?
Yes. That is their position.
And not in effect.
And
on the reservation.
And on the reservation.
That's what they need to prevail, right?
And we respectfully submit that on all grounds that argument violates clear legislative intent.
But exclusive is really the key. If it's not exclusive, then what happens?
If it's not exclusive, it doesn't qualify.
I have a policy question for you. If the state and the tax department, at the time this action was started, had a policy of forbearance and wasn't going to impose these taxes, why is it that the two counties should be able to? The district attorney's offices should be able to.
Judge Graffio, it comes to the issue of this. What the Cayugas are relying on is an enforcement or a lack of enforcement by a government agency. The law is clear. 471 is clear. The tax shall be collected and paid on all cigarettes.
And I guess I'm asking, why should you folks be the enforcement agents when the state hasn't wanted to do it?
Well, I guess with all respect, Judge Graffio, I don't know that it would be the state policy. I think clearly it's the DTF policy. Obviously, recently...
Is it still the DTF policy?
Yes, it is. Well, the DTF has been instructed by the governor to withdraw the policy.
Right, but are they now going to issue regs or whatever?
They're going to take a shot at regs. That's correct, Chief Judge.
Okay, keep going. I'm sorry.
Okay. So what they've done is they're basing their argument essentially on a decision by a government agency, an executive agency, that is absolutely contrary to the clear language of the statute.
It has been the policy for a number of years.
It has been the policy, but getting back to your question, Judge Graffio, about why would these DAs, how can these DAs do this? The district attorneys have an independent duty. The district attorneys are required by law to enforce the law. They are not bound by a decision by an administrative agency, by an executive agency, not to enforce the law as written.
If we agree with you, in the absence of regs, what formula will they use under 471E to determine what taxes are owed?
Judge Graffio, I don't believe that they need to follow under a formula under 471E. In fact, I think Judge Hurley, in the Morrison case, out of the Eastern District, lays forth a very simple plan of how it can be effectively.
Well, the rate is in 471, right?
I'm sorry?
The rate
is
in 471.
Exactly.
You can't do 471E without the rate. You couldn't do it in and of itself.
You wouldn't know what
right?
the amount to pay is. You wouldn't know what to pay. But to answer your question, Judge Graffio.
They develop their own formula?
No, they wouldn't develop their own formula. What they would do is, as Judge Hurley suggests, and I acknowledge I'm borrowing his, I'm plagiarizing here. What Judge Hurley says is that the reservation retailer buys stamped cigarettes, tax stamped cigarettes, to cover his demand, his or her demand for selling to non-members, basically to the general public. And then what the reservation retailer can also do is get a percentage, get some volume of unstamped, untaxed cigarettes that would cover sales to members of the nation.
How do you know
That's-
it's some volume, though?
That you still need a
Based-
formula to figure that out, though, don't you?
I-
There still has to be some equation.
I think, Judge Graffia, the way to do it would be just on a market studies. And what would make it particularly simple here is the Cayugas have identification cards. And so when the purchaser goes into one of the two stores and says, I would like tax-free cigarettes, great, where's your ID card? Or you have your ID card, terrific.
If you're right that this is not a reservation, isn't it even simpler? They have to collect tax from everybody?
Absolutely, absolutely. That comes in only if it's a qualified resident. Our position is these two stores are no different from any two stores out on the corner right here in Syracuse.
And it doesn't matter if it's forbearance. You're saying we can work that out, even if...
No, Judge Lippman, the issue with forbearance is that it's really just a policy of an executive agency. An executive agency can't override the statute.
Yeah, but to actually execute, you have to have some kind of approach to do it. You're saying that even without them doing regs, what you suggest, some other method is easily
Absolutely.
doable, and it just doesn't matter that they choose not to put in place a protocol to get this done.
471 on its face is self-executing.
Are the DAs or your clients trying to collect the tax or just to prosecute for failure to pay it?
Well, Judge Smith, we don't know, strictly speaking, the answer to that question because the indictments aren't opened. I mean, this whole prosecution has been
but they are indictments. They're not lawsuits for money.
That's correct, but we don't know anything more than that. What we do know
What's
is
the ultimate goal? What's the ultimate goal? What are you seeking to accomplish at the end of the day?
what we're seeking, Chief Judge Lippman, is for obviously an order reversing the order of the appellate division and a ruling that this land, these two stores, are not qualified reservations. They are not reservations within the meaning of the
I guess I keep
tax
coming
law.
back to is it possible for us to decide the case without reaching that question? Can we just say whether or not they're qualified reservations, there's you have a case that they're not violating the tax law? Because if they're not qualified, they're obviously violating, but even if they are qualified, they've got to pay tax as to the people who are not their members.
Absolutely, absolutely. At best, if it's a qualified reservation, obviously we disagree. At best, what it is it would allow the Cayugas to sell to members tax-free. Everyone else,
And
non-members, pay.
Are your clients, are the DAs going to collect the taxes?
Well, no, Judge Graffia, I believe the taxes would be remitted to the state, to DTF.
Even though they're not implementing any regs,
Well, 471 doesn't need implementation. It's
So
self-effectuating.
you don't need DTF at all. They're just going to get the money.
Well, DTF, yeah, under
But
471.
but they have nothing else to do with it.
Well, they have to enforce it. That's the problem.
Spillane, could you, I think we're having a little trouble picturing this. I mean, if it's a murder or an assault or something and the DA goes and arrests somebody, we know they're charging him with murder or assault, and we know the statute. Here, the DAs are confiscating cigarettes, as I understand it?
Well, they did confiscate in November of 2008.
Could you just walk us through how we got here? In other words, somebody decided that there's a bunch of cigarettes someplace that don't have the tax stamps on it.
That's correct.
So there's a complaint by somebody. And they say, well, this is a violation of 471, so we're going to arrest the people who are selling cigarettes without the appropriate stamp.
There was no arrest. There was an application to Judge Fisher in Monroe County for a search warrant as to the store in Seneca and Cayuga County.
And the basis of that search warrant was, we have reason to believe that there are cigarettes on this premises which have not been appropriately taxed.
Taxed, stamped, and taxed. Correct.
And so you got a warrant and you went and you got them. All right.
That's correct.
And then based on that information, what did you do? You were talking about indictments. I'm just saying.
Well, what happened, Judge Piggott, really ties into the Kelly's rental case. The day after the seizures, the Cayuga Nation commenced a collateral civil declaratory judgment action.
Right.
And the relief, that's this action.
Right.
And the relief asked for in the complaint was return of the property and an enjoining of the criminal prosecution. And we said from the start that that's improper. All questions such as the return of the property and anything directed to the pending criminal proceeding has to be in criminal court.
Should be over there.
Absolutely.
Right.
Absolutely.
You don't have an accusatory instrument yet, though, right?
Excuse me.
Is there an accusatory instrument yet?
There is. The indictment's been handed up. It has not been opened. I mean, to a certain extent,
So
this
your
case.
posture is there's already been the initiation of a criminal proceeding?
Judge Gravio, the criminal proceeding, at a minimum, was commenced on the application for the search warrant to Judge Fisher.
But a criminal action, which you say is different, was commenced after the commencement of this civil case?
Well, technically, I think you could say that. Well, the indictment's been handed up, but everything is stated.
But the indictment was handed up after they sued you?
I believe it was the indictments were handed up a day or two after that.
I've one question before you sit down. Do you have a position on whether Day's wholesale case was rightly decided?
I do.
What is it? So sorry, two questions.
Judge Smith, it makes sense to the extent that the statute says until there are regulations in place, this won't be enforced. And in that sense, but we're not a Day wholesale case.
Short answer is you do not dispute the Day's wholesale case. You intend to have us assume it's correct.
Well, I understand the rationale, I accept the rationale, but I submit it has nothing to do with our case.
Basically a truism. What they're saying, and they...
Exactly, Chief Judge.
Okay.
Thank you.
Thank you, counsel. You have your rebuttal. Counsel?
What about this justiciability issue? Obviously, we wouldn't have to get into the other parts of this litigation if we decide that it's not justiciable.
That's correct, Your Honor. If the court determined that this collateral attack on the criminal prosecution, if this is a collateral attack, it's prohibited, then that would be the end of the case, and there wouldn't be any further.
Well, if we disagree, or I guess if we also, the question was asked, I think, of Mr. Spillane, if we decided it on the 271, we wouldn't have to talk about qualified reservation?
I guess that depends on how you decided it. If you decided in favor of the DAs and the counties and the position that we are siding with, right, that 471 was the operative provision, which, again, we noted in our brief our agreement with that view, then that would be the end of it, and you wouldn't have to decide the question of qualified reservation status.
But conversely, if we decided on qualified reservation, we wouldn't need to reach...
Again, if you decide that there's no qualified reservation here under the tax law, then you don't need to decide the question of 471 versus 471E, because 471E is only relevant with respect to sales that occur on a qualified reservation.
Well, how can it be relevant if it's not in effect?
I guess the argument that we're making is that, or that we believe that you don't get to the question because 471. Excuse me.
I mean, there are a lot of doors you can enter
right
by. But what if you just enter by the door that said the Day wholesale door, which says 471E doesn't exist? It's not in effect. We don't have to read it. All that exists is 471.
Again, I think that provides a mechanism for determining that 471 is the operative provision. 471 is a provision that broadly imposes the New York State cigarette excise tax to the maximum extent permitted by law.
So this is purely a legal question, though, interpreting that.
Yes, it is.
That's right. There's no factual issues here.
I think that's correct.
So
at this point,
if you look at it that way, it could be determined here in this proceeding, in this.
Yes.
Been brought.
With respect to the qualified reservation issue, I'd like to add a few more thoughts to Mr. Spillane's comments. The whole point of the qualified reservation definition of the tax law is to create an area where the tribes could sell cigarettes to their members free of the state tax that would otherwise be due. And the only reason to defer to the tribes in this manner is to resolve the conflict of sovereignty that would otherwise be present with the state sovereignty over those transactions.
Your view would be that the reservations, as they've been known to exist in New York State for our last 159 years, the last time we were sitting here, are defined geographically, and that's what was meant.
I guess my point more specifically is that when the legislature defined the term qualified reservation, it was in this case, it was building on the history of that term. That term had been used before in tax regulations, and the legislature in this case adopted what had been proposed tax regulations by the tax department in 2003. And the tax department made clear when it proposed those regulations that the purpose of the coupon system was to respect the sovereignty of tribes within their reservations. So the concept of sovereignty was implicit, I think, or maybe explicit in the notion of the definition of qualified reservation, and that was what the legislature built on. And that's not a novel concept, because in 1982, when it adopted the sales tax regulations under 20 NYCRR 529.9, which are still in NYCRR, the definition of qualified reservation there was a list, and there was no Cayuga reservation listed. Likewise, in 1988, when the tax department adopted the ATIA cigarette regulations, which were upheld by the Supreme Court but later repealed by the tax department, the definition, again, a list of qualified reservations, no Cayuga reservation listed. So I think the tax department...
You're saying the terms are one and the same, basically.
I'm saying, yes, that the tax department was building on a history of basically 200 years of there not having been a Cayuga reservation recognized, at least in the state of New York, by the state of New York, and that when it adopted the definition of qualified reservation in 2003 that the legislature later enacted in 2005, that it was building on this history, and that the concept of sovereignty was something that was included in that term. And again, the tax department, I think, made it clear when it adopted or proposed the 2003 regulations that it said that the purpose of the coupon system was to respect the sovereignty of the tribes.
Mr. Bing, were these convenience stores also selling gasoline? And what was the state doing about those taxes?
I don't believe that the state has been collecting the gasoline tax, although I'm focused on the cigarette tax.
And that's not part of this case,
not part of this case, I don't believe, no.
Mr. Bing, I don't think anybody has mentioned City of Sherrill.
Well, I'd like to talk about City of Sherrill because I think that case further emphasizes the importance of sovereignty in this context. The legislature, when it adopted the definition of qualified reservation in 2005, at that time had before it the Supreme Court's determination in Sherrill. And given that decision that the Oneidas were precluded from exercising sovereignty over repurchased lands within their claim area, the legislature would have known that it didn't need to include in the definition of qualified reservation lands the lands of this kind, lands over which lands purchased in a claim area, because the tribe was precluded from exercising sovereignty over them. In other words, there was no risk of conflict with the state sovereignty on these lands because the Supreme Court had just said that claims of sovereignty by the tribe are precluded. And the Second Circuit, following the enactment of this statute, following Sherrill in the summer of 2005, the Second Circuit, viewing this historical record, determined that the Cayugas were similarly precluded from bringing their land claim for the reasons that the court had enunciated in Sherrill.
Do either of those cases indicate whether those courts viewed qualified reservation the equivalent of lands over which you have sovereignty?
The issue in those cases, the Supreme Court in Sherrill said that it was not deciding whether or not there was a reservation. It didn't consider that argument whether the reservation had been disestablished by the Buffalo Creek Treaty. It determined, based on the bars of laches, acquiescence, and impossibility, that the Oneida's claim to tax immunity was barred by their inordinate delay in raising it.
So that's more an open question for us in this case, you think?
Well, I guess I'd like to particularize what I think the question is. I think the question ultimately is, I think, a state law question of interpreting the tax law and the definition of qualified reservation. And our position is that a necessary condition of qualified reservation status under the tax law is the concept of sovereignty being exercised over those lands.
You view the state tax law as going to the maximum extent of the state's power?
Yes, and I think that's consistent with the statutory language in 471 subdivision 1, which says that the tax is imposed broadly imposed to the maximum extent of the state's power. I think this reading is consistent. Where there's no sovereignty of the tribe, the state is sovereign, the state can collect. There is no exemption for sales on non-sovereign lands to members of the tribe. And in essence, as Mr. Spillane said, those lands are no different from any other lands in the state of New York to which the tax is applicable. I would also like to point out, I think, that in resolving this question on the qualified reservation definition, that the court, if the court agrees with us that sovereignty is a necessary condition, it need not address the question of the status of the lands under federal law. I think that the kind of determination that the Fourth Department made in its decision is really the kind of determination that can't be made without an evaluation of a massive historical record. There was a 12,000 or nearly 12,000 page joint appendix in the Second Circuit dealing with these issues. There's nothing like that record in this case regarding the history.
What do you understand the rationale of the appellate division decision on the qualified reservation issue to be?
Your Honor, with respect to the Fourth Department, I was not able clearly to discern the rationale, but the steps in the logic seem to be that there is today extant a federal law reservation, and that's all you need to have a qualified reservation under the tax law. And I guess our basic argument with respect to those steps is you don't need to resolve the first one, and probably shouldn't on this record.
I'm tempted to ask what is a federal law reservation, but you're going to tell me. Please don't get into that. It'll take us all day.
It could. I mean, there's a lengthy, we're talking about evaluating things that happened hundreds of years ago.
Mr. Bing, could we do it another way, though? Let's assume for a minute the Fourth Department's right. The appellate division got this right. What would it take to fix the law to say what you think it says now? In other words, if you just changed qualified to sovereign, would that do it?
I think if the statute were to be amended to make clear what we say it means now,
right.
That sovereignty is a sine qua non of qualified reservation status, then that would be sufficient. We don't think that's necessary because we think that the statute can only mean that now, and that any further legislative action would...
I know your light is on, but does the Urbach case have any bearing on this? Is there any relevancy?
No, Your Honor, not particularly. I think that that made clear that the policy forbearance was not a
do you agree with Mr. Spillane that even if you lose, even if the Cayugas prevail on the qualified reservation issue, that they still owe tax because they're selling to non-members?
Yes.
And so you would say this case could still proceed even if it is a qualified reservation?
Yes.
Okay.
Thank you, Your Honors.
Counselor, proceed. Go ahead.
Thank you. May it please the Court, my name is David DeBruin. I represent the Cayuga Nation. It is a privilege to appear before the Court today. This case arises in the context of a threatened felony criminal prosecution of the Cayuga Nation and its leaders, when just a year ago, the same Office of the Attorney General that stood up before me today filed in court, and I quote, "The state is presently not taxing any sales from Native American lands." And that was a filing in the Master Settlement Agreement litigation. It is included in our response brief to the amici brief, both page 14 and in the exhibits.
Isn't that open to two interpretations? It can mean there is no tax in effect, or it can mean they're not collecting it.
Again, what they argued is the state is presently not taxing any sales. And
I'm asking you whether there's any, whether those words could, in context, have meant simply that the state is not seeking to collect tax.
Well, it could, and that's actually also a very important point that I want to return to. But the reason the state argued this in the Master Settlement Agreement litigation is because it's in the state's interest to show that it is aggressively and effectively enforcing the cigarette tax laws so as to preserve almost $1 billion in annual payments to the state in that litigation that is dependent upon the state effectively enforcing the cigarette tax laws. And so the state has taken the position in that litigation that there is no tax for sales on Native American lands. And that is, in fact, correct under the tax law.
You said there's no tax for sales on Native
That is
American
what
lands, even if I go buy a pack of cigarettes on Native American
That is what the state argued.
Is that true? Is it correct, whether they argued it or not?
Well, I would clarify. And the key to this case on the tax issue, and again, if what the counties are arguing is correct in terms of their interpretation of the tax law, then not just the Cayuga Nation and its leaders, but every Indian tribe in this state or its leaders, every reservation seller, every wholesaler selling on a reservation can all be indicted for doing what the tax department has said is allowed.
My question was whether it is indeed correct that no sale of cigarettes on reservation land can be taxed.
Judge Smith, the key to this case is the difference between
What's the answer to my question?
There is a tax that is imposed on consumers. The text of Section 471 is explicit. The incidence of and liability for the tax shall be on the consumer. There is no dispute.
But do you admit that your clients have an obligation to collect it when there is a consumer who owes the tax?
Judge Smith, that is the issue in this case.
Well, what's your position? You're saying you have no obligation to collect, even if I go in to on a reservation store and I buy a pack of cigarettes. You're saying that your clients have your client or the owner of the store has no obligation to collect the tax?
That is absolutely correct. There is a tax that falls on the consumer. The consumer has an obligation, as the governor has told the legislature every year in his budget filings. The consumer has an obligation to pay
I now
the
understand
tax.
your position. What says that? Is there a case? Is there a regulation? Is there a statute that says that you don't have to collect it?
Judge Smith, it's clear from the entire historical context.
In 1930, then? I mean, that wouldn't apply just to the Indians. That would apply to any store. They have no obligation to collect state cigarette taxes.
No, Judge Pickett, this is only on reservation sales.
Well, no, don't leave it that quickly. Your argument, if it's true, that the obligation is on the consumer, means that if you go into Walmart, you go into Duane Reade, any drugstore, any place in the state of New York, they have no obligation to
No, absolutely
impose
not.
tax.
There is an obligation for retailers to collect the tax.
Is that true of the Cayuga
other
Nation,
than
too?
on a qualified reservation, on a reservation land. And that is true because in 1939, when Section 471 was enacted, it was firmly established that no state taxes...
I don't mean to interrupt you, but isn't that exactly... I mean, we're kind of going around a mulberry bush here because that's exactly what they're saying. You have an obligation to collect this tax, and you're not. You're saying we don't have to because we're on a reservation. That's the whole case.
That was the law well established. In 1939, when 471 was enacted by the New York legislature, it was firmly established that states could not require Indian nations to assist in the collection of tax on reservation land. It was not until 1976.
But I thought you're not asserting sovereignty over these two parcels.
We are not. That is absolutely correct. This is a state law issue. But my point is, the state tax law
So you're saying there's a difference then between qualified reservation and sovereignty?
Yes, and that is clear from Sherrill itself, which decouples the concept of reservation land from sovereign land. But
So what's your definition then of when you say reservation land if it's not sovereign realty?
Well, we believe that the applicable definition is the definition the State of New York, the legislature, has set forth in Section 470.16. There are several different categories. Clearly, the legislature adopted a broader definition.
What category? I'm trying to get more specifics. What's
under
the definition?
Under Section A, a qualified reservation is land that is held by a tribe, must be held, that is within the tribe's reservation. And clearly, the legislature intended in A the same meaning of reservation as is a federal treaty.
You have to go back historically to justify that?
A federal treaty reservation under established federal law of what is a reservation. And clearly, the Supreme Court has held that unless a tract of land is disestablished by Congress, regardless of what happens to the ownership of
as
tracts.
opposed to your adversaries, we have to go back into all the history in order to appropriately decide this case?
No, it is very clear. Every federal court to address the issue
Well,
has
just
held.
accept that general proposition, that if it hasn't been undone or sanctioned, that
You can relook at the treaties, including the Treaty of Buffalo Creek, but federal court regarding the Oneida Reservation, the Cayuga Reservation, have all held that clearly the reservations have not been disestablished. The U.S. filed an amicus brief in this case.
If you have no over lands which are not sovereign, and you admit they're not sovereign,
that is
could
correct.
the state? I mean, I understand you say it's a state law issue. Could the state, if it chose, tax every cigarette sale on those lands?
If the state chose to redefine this as not a qualified reservation, The state
Or,
would
yeah.
then have the power. There only is protection.
Okay, but I guess my problem is we're looking at a statute that on its face seems to say we tax everything we have the power to tax. You're really saying that means we will tax everything that we thought we had the power to tax in 1939?
No, Judge Smith. There is a right under the Supreme Court decision in Moe for an Indian tribe to sell to its own members on its own reservation. So there is a federal...
Even if that reservation is not sovereign land?
Well, that issue has not been litigated post...
But I thought you told me a minute ago that if the state chose to tax what you call sales, even on what you call reservation land, even though it's not sovereign land, the state could do so.
Well, my point was that the state can define reservation. It clearly, in Section 470.16, has defined reservation more broadly than federal law, because we have under Section C state reservations.
Suppose the state passed a statute that says every cigarette sale is taxed except a sale on Indian sovereign land. Anything invalid about that statute?
I believe under Moe that would likely be upheld. It hasn't been decided post-Moe. The word that the court used in Moe was reservation. That was before Sherrill. Whether post-Sherrill, again, what is at issue in this case is the right of a tribe to sell to its members. This case
No, it's
doesn't...
not. It's bigger than that, because up until all of this, on the reservation, I mean, there was never a problem. On the sovereign, people drive there to get cigarettes because they're so much less expensive. Now what you've done is you've moved that off of the sovereign reservation into what people would normally consider the rest of the state, and said, we can do this here too.
But Judge Pickett,
Right.
we don't dispute. The state has the power to require tribes to assist in the collection of the tax if the state puts that in place.
Well, I think we're saying the same thing that I asked Mr. Bing. If we took qualified out and or if the state took qualified out and put sovereign in, then there wouldn't be any dispute.
But my point, yes, that is correct, but they haven't done that. That's a state law issue.
Right.
The legislature can do
Well,
that.
Mr. Bing is saying that's what it says. I mean,
But it doesn't say
Spillane
that.
is saying. Well, isn't that why the seven of us are sitting here? Because we've got to decide whether it says that or not, right?
Well, but clearly, my point is it doesn't say that. What it says is lands held by a tribe within its reservation. As a matter of law, it is clear that the Cayuga Nation still has a reservation. And Sherrill may say we don't have sovereignty over that land, but Sherrill decouples the concept of reservation from sovereignty.
But one way or the other, that's really what we're down to in this lawsuit, right?
Well, that is clearly one of the issues. We admit this must be established to be reservation land. It clearly is reservation land.
Right.
A does not require sovereignty. Section B, 470.16b, does add an element in which there must be governmental power over the land.
So
the
far
legislature did not include that in A.
So far, I haven't heard you talk much about 471E. I was suggesting in the questions to your adversaries that's irrelevant because it's not enforced. Do you agree with that?
It is highly relevant. And the reason for this...
How can a statute that's not effective yet be relevant?
Because the difference in this case is the difference between liability for a tax, which falls on the consumer, and whether the tribes have an obligation to assist in collection. Clearly, there has never been...
But if they had that, either before 471E was passed, they either did or didn't have the obligation.
And
you say they didn't. He says they did. 471E isn't effective yet, so how can it change that either way?
471E was a recognition by the legislature that there was no collection mechanism in place. And first, the legislature ordered the tax department to put one in place.
So if I understand what you're saying that before that it was true before 71E was ever thought of that you had no obligation to pay to collect these taxes, and the passage of 471E is just further evidence of what 471 means. Have I paraphrased you correctly?
If the tribes had an obligation to collect taxes before...
Okay, try my question. Did you agree with what the summary I just gave you?
There would be no need for 471E if there already was a collection mechanism in place.
Well, maybe they just wanted a better mechanism, or they wanted to try a different
The
formula.
history absolutely refutes that. There were regulations in 1988 which were in place by the tax department. Those were repealed in 1998. This court litigated. There was litigation before this court in the Urbach case that upheld the lack of any collection mechanism requiring tribes.
Does it matter if 471 has a rate in it and 471E doesn't? Does that matter? Is that important?
It is important.
Why?
The tax, including the rate of tax, is set forth in 471, which consumers have a duty to pay. The question is, must the tribes collect that? And there is not a collection mechanism in place, and there must be. The county's claim that the tribes can sort of make up their own system is not sufficient. What the counties have argued is that the possession of any unstamped cigarettes is presumptively unlawful, and that the tribes have an affirmative defense.
Well, they're saying that 471 is self-executing.
Right, and what they're saying is any reservation seller can possess, in their words, they can buy some unstamped cigarettes to sell to members, but the possession of any unstamped cigarettes under 1814 is presumptively unlawful.
They're not really, as to non-sovereign lands, I don't think they are saying that. As to non-sovereign lands, they're saying the reservation sellers and the non-reservation sellers are just the same. They've got to do what everybody else does and buy the tax stamps.
Well, they have two arguments. That's their argument on qualified reservation. But on the tax law, they argue, oh, sure, you can possess unstamped cigarettes, but possession is presumptively unlawful. You have an affirmative defense in a criminal case. That is their response. Don't worry, you have an affirmative defense in a criminal case to justify your possession of unstamped cigarettes. That is not a lawful mechanism.
But if they're right about sovereignty, then you don't have an affirmative defense, do you? You just got to pay the money.
Well, of course, if this is not a reservation, we concede we would not have the right to sell. But clearly, under state tax law, it's a state issue, not a sovereignty issue. We don't claim sovereignty, but we claim a right under the tax law that this is reservation land.
So the key statute, I guess everyone's saying maybe, is 471A, which says we're levying a tax subject to the state's power. And you say that, read in context, that does not reach what your client's doing.
Section 471 says, and I quote, "The incidence of and liability for the tax shall be on the consumer." The tax is on the consumer, not the nation, not the Cayuga Nation. The question is, must the Cayuga Nation collect it? Well, that's the question. And where's the exception for Indians in the language that says the seller has to collect it? There is no exception for Indians in 471. It was enacted in 1939 when it was conceded that there was no authority of the state to require tribes to collect the tax in 1939. So basically you're saying that that was so well recognized at the time that even the broad language that says the seller always collects does not include reservation Indians. Well, at the time that 471 was enacted in 1939, the state had no power to require tribes to assist in the collection. That was not recognized until 1976. Or at least the state was not then understood to have the power. It's sort of an abstract question whether it had it. It's not recognized until 1976. Right. I guess, so maybe the question comes down to whether, as the understanding of state power expands, the scope of the statute expands, or you say they have to go back and amend the statute. Is that basically your argument? I think that's an excellent question. Does the state power naturally extend? The legislature has consistently recognized that absent some mechanism put in place by the tax department or the legislature, there is not a springing into life collection mechanism. And the reason for that is you need some system to protect the possession. You can't sell to members without tax unless you're first possessing an inventory. You need some mechanism to assess, well, what kind of inventory can you hold?
Aren't they suggesting, though, a way to go about knowing the inventory that you have?
It doesn't work. What they're suggesting is take your chances. They're saying, take your chances. Go ahead, possess some, and if we decide you're possessing too much and we indict you for it, you can raise an affirmative defense in a criminal case.
They're saying have the tribal members present a tribal card so that you're able,
right. They're not
the operators are able to determine who's entitled to not pay the tax.
Yes, Judge Graffio. They're not suggesting the sale would be a prosecutable event. But the problem is you can't sell to members without tax unless you possess a quantity without tax. And there is no defense, absent some mechanism, to that possession. And Section 1814 says the possession of unstamped cigarettes is presumptively unlawful. And the county's response...
To make sure I understand what you're saying, you mean you don't know whether to buy from a wholesaler stamped cigarette packages or unstamped cigarette packages?
What the counties have contended is that the nations can buy both. They buy some stamped cigarettes to sell to non-members, and they can buy some unstamped cigarettes to sell to members.
So what's illogical or unworkable about that?
Because you have an inventory, Chief Judge, that is unstamped. But under the tax law, possession of any unstamped is presumptively a
I
crime.
think they would concede that you're entitled to have some unstamped.
But how much, Judge? How much? Their answer is, and this is what they've said in a letter to the Fourth Department after argument. They said there is an affirmative defense in a criminal case. That is not sufficiently respective of Indian sovereignty. In the Supreme Court's decision in Milhelm Atiyah, which
So there
came
has to
from
be a
this court.
mechanism. There's no way that 471 can be self-executing. There has to be a mechanism.
Yes, and the state
Correction.
legislature has recognized that. That's why, if you read the original text of 471E, enacted in 2003, the legislature ordered the tax department to implement regulations, and I quote, necessary to implement the collection of taxes.
Well, is the tax department, I understand this forbearance policy, but has the tax department ever taken precisely the position that you're espousing, that there's no way to enforce it without the regulations to collect?
That is what the tax department effectively has done, but it is not simply a forbearance of
Well,
enforcement.
I guess that's not quite the position they're taking today, though.
No, the Attorney General has done a 180. From a year ago, when in a filing in the Supreme Court, the Attorney General said the state is presently not taxing any sales
That's the
on Native
consent.
American lands. When $1 billion is at stake, that's the position of the state. When the Cayuga Nation and its leaders are being hung out and strung between the county and the state comes in and says, we support the county in all of their arguments. And not only the Cayuga Nation and its leaders, but every tribe in this state. And for the state of New York to treat the tribes the way the counties are threatening to do here, basically representations, promises made by the tax department, we will allow these sales to be made without tax.
Well, aren't they
And now to
talking
turn
about-
around and indict the nation and their leaders for doing exactly that.
But aren't they talking about sovereign land as opposed to what we're talking about today, which is the non-sovereign land?
That is one of their arguments, but there is nothing in 470.16 that says sovereign land. It says reservation land. And there is no dispute. This is, well, there is dispute, but this clearly is reservation land of the Cayuga Nation. The federal government has made that clear. In an amicus brief, that's the position of the BIA. Again, if the state legislature does not agree with that position, it has the power to rewrite the law. That's the function of the legislature, not this court to say, well, we don't think the legislature meant what it said, so we're going to rewrite what they said into what we think they must have meant. That's the job for the legislature. If this statute does not comport with legislative intent, they can change it. But clearly, in 470.16, the legislature enacted a broader definition of reservation, qualified reservation, than was required. They included state reservations, which were not necessary to include. And again, if you look at the original definition, the history here is very significant.
So it sounds like under your analysis, that's an essential issue we have to determine.
Well, you
A
have to determine the
definition of
meaning
qualified reservation,
Yes,
what that means.
certainly. But I think the history here is very significant. There was a regulation of the tax department that listed qualified reservations, and it did not list the Cayuga Reservation because at that time, the Cayuga Nation did not hold any land. It had not reacquired land. In 2003, when the legislature first enacted 471E, it did not adopt a list. Instead, what the legislature said was, where a non-Native American person purchases for such person's own consumption any cigarettes or other tobacco products, and then here's the language, on or originating from Native American nation or tribe land recognized by the federal government and reservation land recognized as such by the state of New York. That is the 2003 version of 471E.
And why doesn't that mean sovereign?
Well, they didn't, again, use the word sovereign.
They have
but-
to use that word for that definition.
Well, they have the ability to do that, but just to complete the history. So that's what the legislature said in 2003. In response to that, the tax department proposed regulations that included not a list of reservations, but a definition of qualified reservation, A, B, C, and D, A of which is land held within a reservation. The legislature then adopted that proposed regulation in 2005 in the current version. But it is clear, if you look at the history, that what the legislature was doing was accepting reservation land, quote, as recognized by the federal government. And in fact, the final version that the tax department used in its regulations models a federal statute known as IGRA, the Indian Gaming Regulatory Act, which again creates the distinction between reservation land and other lands over which the tribe has governmental power. It has been held post-Sherrill that the meaning of the word reservation under IGRA does not require sovereignty, that there is a distinction that Sherrill recognizes between reservation land and sovereign land. We're not contending we have sovereign rights over this land, but under state tax law. And we've owned these stores since 2003. The tax department has never come forward to us and said, you can't sell unstamped cigarettes on those lands. That's not a qualified reservation. We've been selling openly without any interruption from the state, from the tax department, until the counties in 2008 executed their search warrants.
You don't claim estoppel, or do you?
We do believe, in fact, that there is estoppel, and if indictments are brought, we will assert every argument that we can.
That is not now before us.
That issue has not been raised, but under decision of this Court, there is estoppel not based on the actions of individual state officers, but where there is reliance upon an agency. In the cases, the Bender case in this Court, 1976.
Before your time is up, could you address why your declaratory judgment action is appropriate?
Thank you. Yes, I would like to do that. It is clear, and no judge, not Justice Fisher or any of the judges of the Fourth Department, believed that we were procedurally improper. On November 25th of 2008, search warrants were executed, seizing cigarettes that we openly sold in reliance on the tax department's pronouncements. The very next day, November 26, 2008, we brought this action for declaratory relief. Under the New York Trade Zone Operators case, it is clear that even in the face of threatened prosecution, so long as two things, the facts are not in dispute, and we alleged in our complaint we're selling unstamped cigarettes. We don't deny that. We don't hide that. We never have. As long as the facts are not in dispute and there is no proceeding that has been scheduled where you can appear to assert your defense, you can file for declaratory judgment. When a search warrant is executed, there was no place we could go.
When were the indictments handed up?
I'm sorry, Judge, I didn't
When
hear
were
you.
the indictments handed up?
Actually, it was, I think, several weeks later, not several days later. But clearly there were no indictments at the time we filed this lawsuit. And, in fact, there might not have been indictments for years,
so your
for
posture
months
is
or
any
years.
time before the indictments were issued, you were able to commence a declaratory judgment action?
Yes. Any time before there was an accusatory instrument that required the defendant to appear and provided an opportunity for the defendant to raise the issues that we're raising here. And in Kelly's Rental, the case relied on heavily by the counties, there was, in fact, a summons that had issued. It's undisputed. If you look at the three-paragraph decision of this Court in Kelly's Rental, there were summons that were issued requiring the defendants to appear at a place and time. And the Court said, well, you've got a summons.
Did the search warrants name any particular individuals?
They did not, Judge, and that's another point. There is no individual who would be foreclosed and not foreclosed just based on a search warrant. And when a search warrant is executed, it could be months, it could be years before there is, if ever.
Okay, Counsel. Thank you.
Thank you very much for your
Appreciate it.
attention.
Counsel, rebuttal?
Thank you, Chief Judge. Very quickly, on this issue of the reservation, qualified reservation, and the definition, obviously we say this is not a qualified reservation. As set forth in our brief at page 30, there is repeated reference to the legislative debate. There's this constant, over and over again, reference to sovereignty, respecting tribal sovereignty. We want to retain tribal sovereignty. So the legislative intent is that the phrase, the term qualified reservation, contemplates sovereignty. The Cayuga Nation points to 470.16b as saying that's where the legislature stuck the sovereignty issue. We disagree with that. 470.16b has two provisions. It deals with restricted fee status, which typically applies with a land claim settlement, such as with the Seneca Land Claim Settlement Act, which is 25 U.S.C. 1774 FC. Talks about that the land would be taken into restricted fee, or an out-and-out land to trust or land to trust application under the IRA, under 465. But when the land is taken into trust, that's what the statute says. 470.16b doesn't even mention the word reservation. So it deals with an issue that is just not applicable to these two stores. The word reservation in 470.16a is the word that implies sovereignty. And that's clear from the legislative intent.
And then but they do, the 16b does use the words lands over which an Indian nation or tribe exercises governmental power.
Correct.
Doesn't that imply that those words mean something different from reservation?
Judge Smith, no. I respectfully submit that the two subdivisions in B refer specifically to the land to trust application or the
But why did they use all those words? Land over which an Indian nation or the tribe exercises governmental power. If they could have just said reservation land.
I think what they're doing, Judge Smith, obviously I don't know for a fact, but I think it makes perfect sense. What they're doing is they're tracking the federal statutes that contemplate when land is taken into trust or taken into restricted fee. Again, the language in the Seneca Settlement Claims Act doesn't track it verbatim, but it's the exact same idea about land being taken into restricted fee. I believe that's what 470.16b applies to, the land of trust and the restricted fee. Reservation, as in A, means sovereignty. And Mr. DeBruin mentioned that after Sherrill, there was a court that recognized there can be the separation of reservation from sovereignty. That might well be the case. I mean, that's what Sherrill spoke about. But this statute was enacted prior to Sherrill. This idea of a non-sovereign reservation couldn't have been conceived of by the legislature.
Was the issue that was decided in Sherrill vigorously debated for a long time before that?
Well, certainly was. Obviously, it went through the Northern District and the Second Circuit. But in those cases...
So the possibility of non-sovereign reservation land could have been contemplated even before Sherrill.
It certainly could have, Judge Smith. But again, if you go back to the legislative debate, again, at page 30 of our brief, the repeated reference to sovereignty, clearly the legislature intended that this land would be sovereign. And the land is clearly not sovereign. They concede it's not sovereign. So we respectfully submit that it can't be sovereign land. On this question of enforcement.
These two parcels are pending with the federal government as lands and trusts.
Yeah, they're making a land of trust
application. If the
application.
federal government accepted those applications, that would change the situation.
Well, yes,
correct?
yes, Judge Graffio. Under the 470.16b, that would fall under the land of trust and would be held in that way, not 470.16a.
Okay,
on this question
Counsel.
of yes.
Lights on. Thank you. Thank you both. Appreciate it, all of you.